Hello, everyone. My name is Sarah Bagley, and on behalf of all of us at Jones Roth, I want to welcome you to today's healthcare webinar, the 2026 Employment Law Update. Today, we have the privilege of hearing from attorneys Jaclyn Rudebeck and Dan Olson from the law firm Watkinson, Laird, Rubenstein. They're going to walk us through updates on non-competition agreements, the new overtime pay tax deduction, new pay stub explanation rules, and other recent state and federal employment law updates. We'll be doing a Q&A session at the end, so please submit your questions into the questions area of your GoToWebinar menu. We are also recording this session, so later today, I'll email the video to everyone who's registered. I also wanted to mention that the slides for today's presentation can be downloaded from the handout section of your GoToWebinar menu. Okay, before we get started, we'll unpause our screen. Before we get started, just a quick introduction to our healthcare practice advisors here at Jones Roth. Our practice success plan provides year-round value to practice owners and administrators, helping them to maximize their operational and financial performance. We also support the personal success of practice owners through integrated tax, retirement, and financial management planning. Okay, we'd like to thank our generous webinar sponsor. Watkinson, Laird, Rubenstein provides a broad range of legal services to healthcare practices. With expert knowledge of the complex regulatory environment, their attorneys help navigate the challenges of operating a healthcare practice. I am pleased to introduce our speakers today. Jaclyn Rudebeck is an experienced employment and business attorney and has been working with healthcare practice clients since 2007. In addition to her experience as outside counsel, she's held internal executive roles in the nonprofit and private sector, and she can relate to the many demands her clients face. Dan Olson's practice focuses on business and healthcare, including navigating regulatory issues, transactions, employment issues, contracts of all types, and protection of intellectual property. Jaclyn and Dan, thanks for joining us today.
Thank you for having us. So Dan and I are going to trade off a little bit during today's presentation, but of course we've got to start with a disclaimer because we wouldn't be lawyers if we didn't do that, right? So we're going to start by just reminding everybody that everything that we talk about today is general information regarding Oregon and federal law, and it's not intended as specific legal advice to any of you who are on this call. You all should consult your attorney or your practice to determine which laws are going to apply to your organization, how to comply, depending on the unique facts of your own situation. And if you decide to ask us a question during this presentation that doesn't create an attorney-client relationship, and any questions that we talk about together today are not going to be privileged or confidential. Okay, so as Sarah said, we're going to walk through a wide range of legal topics today, so I'm not going to spend much time on this slide. But first, we're going to take a quick poll so we have a better understanding of who's on the call with us today. So Sarah, could you go ahead and launch that, please? We just like to know the role of who is on the call. We've got practice managers, HR folks, administrators, or the owners or managers of the practice. Looks like, as is typically the case, we've got a majority of administrators or HR managers on the call with us today, but a couple in the other category and also some owners as well. Sarah, do you think we've got just about everybody? I think so.
Yeah, I think so. Do you see those results?
I do. I see on the screen. Yeah. Great. Okay. Thanks, everybody. It's helpful to know. So I'm going to turn it over to Dan to talk about non-competition agreements and the interesting times we've got going on.
All right. Welcome, everyone. So before I get into the exciting new action and non-competes, I just want to spend a moment talking about the old, or current non-compete laws that apply to all industries, not just healthcare. And generally, this gets revised every couple of years to get a little bit narrower and a little bit harder to enforce these non-competes, but we still have it for now until the legislature changes it. So a few important components. You have to either notify employees in writing 2 weeks before they start their job, or you have to put a non-compete in place when people get a bona fide job advancement in order for these to be enforceable. Generally, bona fide job advancement means moving from non-management to management. If you're talking about a healthcare provider, it's hard to do this outside of moving from really a non-owner to an owner, with some other pretty narrow exceptions. In order to be enforceable, non-competes, employees need to be salaried and exempt, and making at least $116,000. Last year, it goes up every year, generally tracking inflation. There's this odd phrase called a protectable interest that the employer needs in order to have an enforceable non-compete. These are generally trade secrets or competitively sensitive or confidential business information. This is a kind of a squirrely one for healthcare. There hasn't been good litigation discussing exactly what this is in healthcare. There's a general assumption that it probably means something like patient lists. I've been waiting for a court to say, gosh, in healthcare, for most medical practices, there's just not really a protectable interest. That hasn't happened yet. It may or may not. We'll wait and see. Reasonable geographic scope. This is generally, a place like Eugene is maybe something like 15, 25 miles. Portland might be smaller, might be like 5 or 10 miles. If you get, Eastern Oregon, smaller towns, maybe it's a little bit wider. Maybe it's something like 50 miles. Again, not a lot of great litigation on this to tell us exactly what it should be. Term, no more than 12 months, a year after termination of employment. And a pretty new rule is that employers have to provide a signed copy of the non-compete agreement within 30 days after the termination. Now, new rules. This is where things get exciting. For those of you who are tracking this, there was a big corporate practice of medicine change to Oregon law in the last year. In fact, there were 2, and pretty unusual. They passed a law and almost immediately passed an amendment to it. That really never happens in the same session, but they were fired up over this. This was kind of tacked on to the end of that Corporate Practice of Medicine Act, the change to non-compete agreements, and this applies only in healthcare. Now, really important, we're still under the old rule. We have to fit into all of those boxes and fit into the new boxes here. The general rule is, for the most part, there aren't non-competes for healthcare providers anymore, unless you can fit into these pretty narrow boxes. And this is retroactive, so this applies to non-competes that were signed 10 years ago too. The first bill that was passed didn't actually have this retroactive piece to it. And then when they passed the amendment, this had a retroactive component. So it applies to all non-competes regardless of when they were entered into. Okay, so the first important part is, who does this apply to? This is generally your medical practitioners. So this is your physicians, your PAs, your NPs, and your naturopathic physicians. Okay, here are the big exceptions. There are 3. Owners are generally exempt from this new rule. Again, still have to fit under the old rule, but the healthcare rule in particular, as long as you have at least a 1.5% ownership, which is pretty small, then you can fit under this exception. When they passed the first rule, again, it was 10%, and it dropped to 1.5% for the amendment. So this one's a pretty easy hurdle for owners. The next exception, they don't say it's for associates in the bill, but that's really who it is. This is for employed providers. Really, there are 2 components to falling under this associate exemption. There needs to be a certain amount of recruitment investment. You need to show that you have spent 20% of their annual salary on generally onboarding costs. So what you pay to a recruiter, what you pay maybe to market for recruiting, sign-on bonus, education that you need specifically for a new employee. Support staff is really vague. I suspect that this doesn't mean, if a physician has an MA for the year that's getting $50,000 salary. I don't think that counts toward this, but it's really unclear in the new statute. But tech costs of onboarding, license fees that are all part of onboarding. So you have to provide this documentation to the provider in order to have an enforceable non-compete. The rule does not say when. Is it at the beginning of employment? Is it at the end of that first year, maybe once you've tallied all your costs, or is it when you actually want to enforce it? We don't know. To be determined. And then there's a time limitation here, and that time limitation starts from when they are hired. If you're not in a shortage area, physician shortage area, then it's 3 years from when they're hired. So if they end their employment after 2 years or less, then you still get that full 12 months. Any later than that, you either get no amount of non-compete or truncated. If you're in a shortage area, healthcare shortage area, then you get 5 years on this. To me, it seems backwards. I'm not sure why they did it this way, but that's what they did. And then the last exemption is easy. This is administrative folks only, so folks who are not providing any medical services themselves are exempt from this, and we can have them be subject to non-competes. Now, the last piece of this is not actually non-compete. This is non-disclosure and non-disparagement. This was tacked on along with the non-compete. This one is written very strangely. Generally, it says we can no longer have non-disclosure agreements and non-disparagement agreement for these providers. Two exceptions. One is a reasonable and somewhat obvious exception. If we have a severance agreement, a separation agreement that we negotiate, then we can have some sort of a non-disclosure, non-disparagement along with that. This is, we've negotiated something, we're handing you money in exchange for you keeping your mouth shut. And then there's a really odd exception for post-separation non-disclosures, non-disparagement only. And this seems to say when you enter into an employment agreement, you can have a non-disclosure and non-disparagement that goes into effect after the relationship ends. And again, that doesn't make a lot of sense to me. And you still have to have a carve out allowing these providers to make whistleblower complaints. But something about the way the language is written seems off. And I think there's likely to be fights over it, and we'll get a better idea of what it really means. But one reading of it really indicates, sure, you can do whatever you want starting at the end of employment. And I just suspect that's not how it's going to shake out. And Jaclyn, I will hand over to you.
Okay, thanks, Dan. Okay, so we're going to talk through kind of a grab bag of topics today. The first one that I wanted to cover is a House bill that was passed in the last legislative session that became effective in January. And this is related to any print materials or web materials where we've got healthcare professionals that use the word doctor. So, whether we're talking about a chiropractor, a PhD in some cases, or an MD or a DO, those materials, the electronic and printed material, have to actually designate which healthcare profession the degree was earned in. And it's got to be in specific, there's some specific requirements for how that content gets displayed in terms of size requirements, the legibility, and the color of the font. So this is just a reminder to, if you have handouts, waiting room materials, signage, websites, to take a look at that and make sure that you've got the actual degree that your providers earned listed there specifically. This is an Oregon requirement. Okay, now we're going to talk about taxes a little bit. So last year, the very large federal tax bill that was passed included a lot of things. One of the things it included was the ability to deduct certain overtime wages from income taxes. So this is primarily a responsibility that the employee holds, the employee that earns that overtime, but the employer has some responsibilities too. So what's now deductible from wages, and this actually applies starting with the tax year 2025, so the taxes that people are preparing and getting ready to file now, what you can deduct is the time. So an employee that earns overtime wages gets time and a half, right? So what they're able to deduct is the and a half part, so that 0.5 on top of their regular straight time rate. That's what they're now able to deduct from their income taxes. It doesn't affect the rules regarding when you have to pay overtime. It doesn't affect the employer taxes that get paid on those wages. Those wages are still subject to Social Security and Medicare tax, so we're not changing the payroll taxes that we're filing on those overtime wages. But what we do need to do is we have to report overtime wages separately on employees' W-2s. The IRS has been a little bit slow in getting specific guidance out on exactly how they want to see this going forward. And so there is an exemption for penalties for the tax year 2025. W-2s have already gone out, but the employer does have the responsibility to separately report overtime wages, and you've got to tell employees, so if you're putting that in a separate box on the W-2, is what's in the box just the and a half deductible portion, or is it all of their time and a half, and the employee has some responsibility to figure out the deductible amount. So this currently expires after tax year 2028. We'll see if it gets renewed, but if you are getting questions from employees, this is why. So talk to your legal counsel, talk to your CPAs about this as well if you need additional supporting guidance on this piece. Also on the topic of kind of wages and pay stubs generally, so in Oregon last year, our legislature passed a new requirement that we essentially have to provide kind of an answer key to explain pay stubs and explain all the abbreviations and codes that appear on an employee pay stub. This was effective January 1st, and what it requires is that actually at the time of hire, so not with your first check, but at the time of hire, you need to provide your employees with a written explanation of every earning and deduction code that appears on their pay stub. So, you know, any deduction that we have for taxes, any other deduction codes, and then also the earning codes that employees can expect to see. So if there are abbreviations that your payroll software platform prints on those pay stubs, these are the things that you have to describe in this pay stub explanation handout. You've got to update it annually. You can provide it to employees electronically. BOLI has created an example that's available on the BOLI website. And there is a $500 penalty for non-compliance if you don't make this available to your folks. There's a BOLI can levy a penalty against you. Okay, so another new requirement that I'm going to encourage all of you, if you use any sort of written employment application, this is a good reminder to take a look at that application, because as of September of last year, Oregon passed a bill specifying that not only are we not going to ask our job applications, our applicants rather, our candidates, for their age or date of birth. We know we're not going to do that. We're also not allowed to ask them for their graduation date or dates of education or attendance at an educational institution. And the theory there is, well, if I'm asking for graduation dates, that's just another possible way that I could discriminate on the basis of someone's age. And so we're not allowed to ask that at any point in the hiring process until the conditional offer of employment has been extended. And the exception to that is if you need to comply with some law or regulatory requirements or confirm that a job qualification has been satisfied by this candidate, you can ask, have you completed this requirement? But if you're in, a lot of platforms, applicant tracking platforms and written job application forms ask for, they've got fields built in that ask for, you know, date that, or the degree that you completed and the date that it was completed. So we want to be really careful about taking that field out of our application process. The other thing, which is not on the slide and is not from last year, but just a reminder, because I still see this coming up for employers. I actually just saw it in a personnel file that I got sent yesterday. Remember that we're also not allowed to ask on our application forms or ask our candidates their rates of pay at previous positions. We're not allowed to ask for that information or consider it when we're setting compensation. So take another look at those, make sure that question is no longer there. Okay, so back to the, I think we got a little out of order here, but back to our pay stub explanations. So we've got to include all of the following information. We've got to include pay periods. We've got to include the pay rates that employees might be eligible for, the wage codes that appear on those pay stubs with definitions, deduction codes with definitions, and it's nice if you can kind of break these out into different categories, makes it easier for employees to understand. Including any benefit deductions, taxes, any other legally required deductions, and then any other codes or abbreviations that might appear on those pay stub documents along with explanation. Turning to Paid Leave Oregon, which continues to be updated. We are, what, in year 3 of Paid Leave Oregon actually being live? It's still, every time I see 2026 written out, it still looks like a fake year to me. So I'm still kind of catching up that is indeed the year that we are in. But our Paid Leave Oregon rules have gotten clarified yet again. So a couple of changes that were adopted last year. The employment department is now explicitly allowed to disclose the benefit amount that an employee is receiving to the employer. The reason this is important is the rules allow you, so employees have to be allowed to use their PTO while they're on Paid Leave Oregon. So if an employer provides PTO, then the employee's got to be allowed to use that, but the employer can actually cap that at 100% of their total wages. So if an employee is getting some amount from the Paid Leave Oregon program, we can, as an employer, limit the amount of PTO that they're able to use to just make up the difference so that they're earning 100% of their wages. Some people on PLO get 100% of their wages from the program, but many folks don't. It depends on your earning level. So the cap was very difficult to administer previously because we didn't have visibility as employers to the amount of benefits that someone was actually getting. So this legislative change made it clear that the employment department is going to disclose that benefit amount to employers so that we can administer that top up or that cap if that's how we choose to do it. It also clarified that employers can require return to work certifications from a medical provider. So if somebody's been out on leave and they're planning to come back, we can require a return to work certification that they're able to do so. It also clarified that the employer can require employees to report on their status while they're out on PLO. So similar to during, FEMLA or what previously, OFLA is really narrow now, but OFLA leave, it has been explicit in the law the whole time that employers can require folks to periodically check in and report on their status. That was now made explicitly part of the PLO rules as well. And it also clarified that employees can use Oregon sick time for all the purposes that are covered by PLO. So remember, Oregon sick time is a totally separate law than the Paid Leave Oregon laws. And Oregon sick time is that rule that requires us to provide at least 40 hours of protected and in most cases paid sick time to employees. This is just clarifying that those two programs work at the same or apply to the same sets of circumstances for employees. Couple other Paid Leave Oregon updates or sick time related updates. So there was a Senate bill that explicitly included time off related to donating blood as a protected reason that employees can use Oregon sick time. Now, this is supposed to be via a program that's approved by the American Red Cross or American Association of Blood Banks, but in general, look at your paid sick time policies and make sure that you've got time off to donate blood covered as a protected reason that someone can take sick time. And also, we've got some clarification about the interplay between short-term and long-term disability insurance and Paid Leave Oregon. So the insurance companies got, I think, a little creative, a little wise once Paid Leave Oregon became live and tried to add requirements to their policies stating that an employee has to exhaust their, in most cases, state-provided Paid Leave Oregon benefits before they could apply for or qualify to use their short-term disability and long-term disability benefits. The state of Oregon said, no, can't do that. So those insurers that write those policies are no longer permitted to include that kind of limitation. Okay. Now we're going to talk about BOLI a little bit. Some of this might be a refresher for some of you, but BOLI has for a long time provided what was previously called technical assistance to employers. There's a helpline and other materials and services that were available to employers. They kind of rebranded that. So House Bill 2248, which was effective last September, changed that employer assistance, the nomenclature regarding that. So now it's called Employer Assistance Division, or EAD. BOLI is going to continue to provide the same type of support. So they've got their hotline, there's an email address, they have trainings that they offer to employers. The communication between employers and the EAD is confidential. It's screened off from their enforcement division. So if you call, I'm still probably going to call it technical assistance. If you call the EAD and you pose a question to them, that's not going to then trigger any sort of BOLI enforcement activity against your practice, your business. So keep that in mind. What the EAD is also going to do is issue advisory opinions upon request. So if there is a wage and hour question that you want clarification on, in addition to the option to contact the support hotline or send them an email, BOLI can also issue an advisory opinion, which would be more publicly available to address that question. This could be a really helpful feature because, as Dan alluded during his segment of the discussion, we don't always have a lot of case law in Oregon. We, just given the size of our population, and we don't have a lot of litigation that makes it all the way through to the end of a case that gives us the ability to interpret some of the more ambiguous rules in our laws and regulations. So advisory opinions from BOLI might help fill in some of those gaps and give us better ability to interpret what did they actually mean when they wrote these words in this regulation. Also, this rule specified that BOLI is prohibited from issuing a penalty against an employer so if you contact the Employer Assistance Division and you rely on their advice in good faith, and then later there is some sort of BOLI enforcement action because an employee filed a complaint, if you rely and can demonstrate that you relied on that EAD advice, there are certain penalties that are not going to be able to be levied against you as the employer. Okay, I'm also going to cover some changes to the statute of limitations for filing of actions. So you may remember, you may have had the experience of defending against a BOLI complaint filed by an employee. The old rule is that at the conclusion of that BOLI complaint process, the division would issue what we call the 90-day right to sue letter. And that meant that that complainant then had 90 days to decide whether or not to file a civil lawsuit. The practical result of that is it sometimes meant that it could have shortened the otherwise applicable statute of limitations, whether it was a 2-year statute of limitations or 5 years, depending on the type of employment claim it was. There was remaining time under the law on that statute of limitations. The BOLI issued this 90-day right to sue letter that could have shortened the time that the complainant had to file that case. So this new rule changes that and kind of fixes it. So if the result of the BOLI complaint is a finding of no substantial evidence, so BOLI said, yeah, we looked at this, we don't really think there's a violation here, we're dismissing it, then the claimant has either 1 year or the remainder of whatever time was on the statutory time limitation, if it was shorter, to file their civil case if they choose to. If there was a finding of substantial evidence, or if BOLI dismissed it with no investigation, which they occasionally will do, then the claimant has whatever time remains on the statute of limitation under the law. So, 2 years, 5 years, that time remains, and that's calculated from the time when the underlying violation occurred or is alleged to have occurred. So in either case, the claimant has no less than 90 days to file suit. So we're extending the amount of time in all cases that a claimant has to file a civil action if they choose to. We also, as employers, are prohibited from entering into any agreement to shorten the statute of limitations. I've actually never seen that, but it's explicitly stated now that we can't shorten any statute of limitations for any law that BOLI enforces. This is definitely a just talk to your attorney. Don't try to make sense of all of this stuff yourself. Okay, some other updates. So this is sort of a little known rule, but places of public accommodation in Oregon must accept cash payments for in-person services. And BOLI has been tasked with explaining and publicizing and enforcing this requirement. I just checked a few days ago. They haven't published any new guidance on this. It doesn't look like there's been much action on this, but just a reminder for folks that if in-person services are being provided, then we are supposed to, we're required to accept cash payments. On a totally different topic, last year, the legislature passed an expansion of unemployment benefits. So this is for unionized workforces, that employees can actually file for and qualify for unemployment benefits if they're off work due to a labor strike, and that can get approved. There was, so we are in a mini legislative session right now. There's a few more days left in the current legislative session. And there was an effort to repeal this new law, which was just passed last year. There was an effort to repeal this during the current legislative session, but the last I checked, that effort had stalled. So it doesn't look like that repeal is going to pass. This doesn't directly relate to medical practices, but I wanted to include it anyways in here. So there was an expansion of liability for wages for general contractors, so construction contractors, but also property owners. So practices that own property can be liable for unpaid wages for workers that worked on improvements to the property, even if they were employed by a subcontractor. So subcontractor doesn't pay its employees, the property owner and the general contractor can then be liable for those wages. Now, there are some specific timelines in here. There's some specific notice requirements, but we just wanted to make sure folks are aware of that. And all three of these rules became effective on January 1st of 2026. And then, like I said, we're in a current legislative session right now. So a couple of bills that I wanted to call to folks' attention. So currently in Oregon, as employers, we can set a policy regarding whether we pay out accrued but unused PTO upon termination. We've got to be consistent about that. Ideally, that's a policy that's in writing, but we can set that policy currently. There is a bill in the legislature right now that looks like it's going to pass probably that would change that and would require payment of accrued but unused PTO to folks upon termination of employment. So we'll keep an eye on that, but it does look like that's going to pass. That would be consistent. So that's been the rule in California for several years. There are a couple of exceptions, but for the most part, once employees earn that PTO, it is considered wages they have earned, and so it gets paid out to them upon separation. So if this officially passes, we're going to need to update employee handbooks for folks that previously had a policy where unused PTO is forfeited upon separation and is not paid out. So we'll keep an eye on that. House Bill 4089 is an interesting one. So there already is an existing crime on the Oregon statutes for theft of services. So that's already a criminal violation, but there are some proposed amendments to that, which the initial version of the bill included a lot of detail, really focused on, if you fail to pay somebody, overtime is required. If, you're late on payment, and it really included a lot of specifics about what they were proposing to add to theft of services. The most recent amended version of this bill walks most of that back, but it does include obtaining services with the intent to avoid full or partial payment, a criminal offense. It makes that a criminal offense. So right now, this one, it actually just had a work session 3 days ago, and it does look like that's going to pass. There's also some other stuff in that bill that mostly relates to construction labor contractors and farm and forest labor contractors, but the piece that I'm most specifically paying attention to is this theft of services. And it'll be interesting to see. I think there are a lot of law firms that really specialize in wage claims, and I wonder if once this passes, which it looks like it's going to, if that changes their approach, or if that adds to the arsenal that those firms employ to follow up on potential wage claims and violations. And then the last one on this slide is a bill that would amend our Oregon disability laws, so that our laws that protect individuals with disabilities. It would allow them to bring a support person with them in any discussions about reasonable accommodations. And it would also require, in our job postings, where we would list the physical requirements of the job, we've now got to connect the dots between those physical requirements and the essential functions of the position. Now, in my opinion, this is kind of best practice anyways. You really want to understand, if you're listing these physical requirements, why are those the requirements? And if challenged, would that actually hold up? Same thing with your essential functions of your position. So this is a good reminder. This was last referred to the Ways and Means Committee on February 13th. I don't know if this one is going to pass or not. It looks like it probably will, but either way, it's probably a good reminder to take a look at job descriptions, create them if you don't have them, make sure that we're addressing physical requirements of the job and that we're listing the essential functions of the job. But when we say essential, it really is essential. What are the core requirements of this position? It's really helpful when you get into any possible accommodation conversation with an employee and you're in that interactive process to have this documentation already exist before then. So it's a little reminder for you. And another hot topic, and this really is jumping all over the place, I apologize, but is we wanted to address something that we covered last year, which is immigration enforcement. So anybody who's been paying attention to the news knows that this is a topic that there's a lot going on, we'll just say that. So two things for employers to be aware of is, first of all, be prepared for I-9 audits. That is something that ICE can do, is to request an audit of all your I-9s. There are fines associated with that if your I-9s aren't complete or updated. The way this process would begin generally would be a notice of inspection. And if the notice of inspection is received, the employer has 3 days to produce those I-9s. You also have to notify your employees. If you receive a notice of inspection, you've got to notify them within those same 3 business days. So might be a good time to audit your I-9s proactively, just make sure that you're prepared. The other one that I think a lot of employers are getting a lot of questions from employees about is, what do we do if ICE shows up at our place of business? So in general, and there are some exceptions to this, but in general, ICE agents under the law cannot enter a private space without either consent or a judicial warrant. So consent is you give them permission to enter. Judicial warrant is a document that is signed by a judge. It's not an administrative warrant, is a judicial warrant. That's different. So keep that in mind. We're encouraging all employers to designate a representative. So if ICE agents appear at the premises, that employees should know, who do I contact, who's authorized to speak on behalf of the business. Of course, try and encourage all employees to remain calm, not place themselves at risk or at risk of harm in that situation. The other thing that we're encouraging is make sure that areas that are private are labeled that way. How are we defining a private space? In general, that's going to be a space that's not typically accessible by the public. Often they're behind locked doors. That can be a factor that can also indicate that that's a private space. But having them, labeled as private can help as well. Okay, coming to the tail end, I think, of our materials today. Wanted to talk also about independent contractors. So this is a very hot off the presses topic. So yesterday, the U.S. Department of Labor proposed a new rule, or announced a new proposed rule that would rescind the last U.S. Department of Labor final rule that was adopted about 2 years ago in March of 2024. The test for determining who is an independent contractor for purposes of the U.S. Department of Labor and the enforcement jurisdiction that they have was a 6-factor test, and I've got the factors listed here, but the factors in that test are opportunity for profit or loss depending on managerial skill, investments by the worker and the potential employer, the degree of permanence of the work relationship, the nature and degree of control, and I should have put a star by that because one of the common themes in all of the tests is kind of the direction and control that's exerted over the person doing the work. The extent to which the work performed is an integral part of the potential employer's business and the skill and initiative required to do the work. So that's the current U.S. Department of Labor final rule federal test. And there's a new proposed rule as of yesterday that would rescind that and would change it back to a core factors test. So, and I actually have that up on my other screen. Those core factors would be the nature and degree of control that the employer, and I'm using the word employer here as shorthand, but the business has over the work that's being done, and the opportunity for profit or loss on behalf of the contractor. So right now there's going to be a period of public comment, and then we will watch for a new final rule to be issued. The reason I always bring this up, though, is that's what's happening at the federal level with the Department of Labor. But there are multiple other tests that we've got to pay attention to when we're analyzing whether somebody truly is an independent contractor or not. There's a test that the IRS uses. There's a test that Oregon agencies, including the Department of Revenue, the Employment Department, the Division of Consumer and Business Services, and the Workers' Comp Division, they all apply a test that's in statute in Oregon, 670.600. And then BOLI has its own test. So there's a link to a website here that provides a really nice overview of the rules in Oregon. But the reason I like to talk about this is it's never sufficient to just pay someone on a 1099 basis and that's the end of it. You really need to assess risk of paying someone as a contractor and make sure that they actually satisfy all of these different tests. So talk to your employment attorney, make sure you're paying attention to this stuff. The tests at the federal level keep changing. Oregon's tests haven't changed in quite some time. So just a reminder to pay real close attention to independent contractor rules because it's complicated. And then finally, a couple of, before we turn over to Q&A if we have any, a couple of notice reminders. So these also aren't new, but I like to remind folks about them. They come up fairly frequently in my practice. So under the Oregon Workplace Fairness Act, which requires us to have specific content in our anti-harassment and discrimination policies, we've got to have those policies available in the workplace. They have to be provided to all new hires, but they also have to be provided to anybody who makes a complaint or releases a claim. So we need to provide that policy again anytime somebody brings a complaint alleging potential harassment or discrimination. We've got to provide them with a copy of that policy, even if we know they already have it, even if it's in the employee handbook, they've got access to it, we are required to provide them a copy of that policy at that time. So keep that in mind. The other thing that we need to be providing to employees is there's a notice requirement under the Pregnant Workers Fairness Act and Oregon law. There's an Oregon model notice about pregnancy accommodation and rights of pregnant employees. That notice should be provided to all new hires, but also it should be provided within 10 days that someone gives you notice of their pregnancy. This is one that I think employers miss a lot. So someone comes to you and says they're expecting, you've got to provide them with a copy of that notice at the time. Just a reminder. Okay, with that, I will check in with Sarah to see if we have any questions in the chat, but if there are any, this is a great time to put them in there.
Yes, we have a question about I-9. Do we need to have employees update I-9 if there have been no changes?
If there have been no changes, not necessarily, but there are certain circumstances that do require updating I-9s. So expiration of documents, name changes, things like that. So potentially there are updates that need to be made. The I-9 form has also changed a few times in recent years, but it was not required that everybody do an updated I-9 when the new form was rolled out. But it's important and it's a good practice to go back through those and scrutinize them and make sure that if it's an old one, that everything, first of all, all the fields were actually filled in at the time that it was completed, and then check and make sure nothing has changed that would require an updated I-9. Dan, anything you want to add to that? Dan might be muted.
I'm muting myself. No, I think that covers it pretty well. Nothing to add.
Okay. Okay, a follow-up question. If the license has been expired, we need to have a new form signed?
If the driver's license is expired?
I believe so.
Right, okay, so
Yes.
yeah, so the driver's license is confirming their identity. But, I would say let's make sure that we're updating our documents so that we've got current stuff. I mean, if it's expired at the time they present it to you, then that's not going to meet the qualifications of the documents list.
Okay, and here's one more question. I think it's also talking about I-9. What about employees who have been with the company for 30 or more years?
Doesn't change the requirement. We're going to want to make sure that we've got an I-9. If they've been with the company that long, then there's chances that we don't even have one, and this is a good time to make sure that we get one in place.
Okay,
I've
great.
seen that come up with, yeah, folks that have been part of companies for a really long time, and those requirements didn't even exist when they were hired.
Perfect. Okay, that was all of our questions. Jaclyn and Dan, thank you both so much for sharing your expertise with us today, including those late-breaking topics. And a big thank you to all of our attendees for joining us. We hope you're walking away with a better understanding on these employment law updates and that you found today's presentation helpful. Take care and have a great weekend, everyone.
Thank you, Sarah.